No, it's fine. I don't want him sitting. I don't know where he is, and he can go now and then come back. Thank you.
Oh, we're good.
Where's our evidence point?
Sure. You can bring the gallery back in. Detective Johns, the state's going to call another witness, and I think it will take us to the time, so there's no need for you to stay. We're just going to start back with you at 9 a.m. Okay, it will be 9 a.m., even though they're requesting some kind of hearing, but I'm not going to do the hearing. Okay, I'm going to hopefully finish your testimony tomorrow, okay? For the record, I'm going to still admonish you, meaning just remind you that you are still in the witness stand. You cannot discuss your testimony with anyone. Do you understand that?
Yes, ma'am.
And you'll abide by it?
Yes, ma'am.
Okay, thank you. I'll see you tomorrow morning at 9, okay? Thank you. Okay. Everybody, is everyone ready to go back on the record?
State's ready, Your Honor.
Okay, let's bring in the jury.
You're in the courtroom, Your Honor.
Thank you. All right, welcome back in, members of the jury, and everyone may be seated. Members of the jury, the state is going to call their final witness for scheduling purposes, and then after this witness, we'll break for the day just so that you know what the remainder of the schedule is. I'm again going to remind you that we pause the testimony kind of midstream of Detective John, so we'll start back with him in the morning, okay? All right, you may proceed.
And please the court, Glenn Fahrig.
Glenn Fahrig. Good afternoon. All right, if you please raise your right hand to be sworn in.
Sir, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
All right, thank you. This way, sir. You may proceed.
May it please the court. Please introduce yourself to the jury.
My name is Glenn Fahrig, F as in Frank, A-H-R-I-G.
How do you pronounce your last name?
Fahrig.
Eric. Welcome to Jacksonville. Could you please let the jury know what you do for a living?
Good afternoon. I work as a forensic biologist at the Forensic Science Lab in Washington for the Bureau of Alcohol, Tobacco, Firearms, and Explosives, otherwise known as the ATF.
How long have you been so employed?
I've been with that laboratory since November of 2017, so almost but not quite 9 years.
And during the course of your experience in working for the ATF Forensic Biology Unit, have you been allowed to come into courts like this one and provide your expert opinion in the field of STR DNA technology and the statistical component to that?
Yes, I have previously testified to the work that I've done.
And Your Honor, this time I would tender, without going through his entire training and background, for potential voir dire as to this qualification.
Any questions?
No, Your Honor.
Okay, thank you. You may proceed.
So since you've been testifying as an expert in DNA, could you explain to the jury what deoxyribonucleic acid is and why it's important forensically?
So DNA, or deoxyribonucleic acid, is something that's found within the cells of living organisms. You can think of it like a set of blueprints or instructions that tell a living thing how to develop and grow. It can be useful in a forensic context because there is some variation between individuals with regard to their DNA, so that we can use it to distinguish between individuals. It is fairly consistent throughout the body, so if your body produces it, it doesn't matter what type of sample it is. If the DNA comes from sweat or from skin or from bones or from teeth, the DNA profile is expected to be consistent throughout an individual. The DNA is also persistent over time, so that if we test DNA from an item from a crime scene and then months or years down the road we test DNA from an individual and do a comparison, we expect that DNA to retain its properties over time.
In other words, your DNA doesn't morph as you age.
Right. Your DNA is not expected to change with respect to the markers that we test and the profiles that we obtain as you age.
So the forensic differences that you look at to distinguish between individuals, are those locations on the DNA molecule, do they code for things like hair color or eye color or things like that?
We do a type of testing that's referred to as STR testing. STR stands for short tandem repeats. These are sections of DNA that do not code for physical characteristics.
So how, you briefly mentioned that DNA can be found in all of your cells. How is it left behind at a forensic scene? You mentioned some of those things, but just explain how it's left behind.
There can be a couple of factors that determine how exactly a DNA profile is left. There's a phenomenon which we would refer to as touch DNA, the idea that someone can touch or handle an object, and without saying with absolute certainty where the source of that DNA is from, it's possible that there are material from the skin cells that could be deposited. There could be secretions from the skin layers that could be deposited. There could be, if somebody has habits of touching their face or touching the area around their mouth, DNA could be moved around. But the idea is, however the DNA arrives and is deposited on an item, there is this concept of touch DNA where something could simply be handled or touched and leave but not behind enough material that somebody could come behind and test that item and get a DNA profile.
So in addition to touch DNA, is leaving your blood behind, leaving your spit behind, leaving your semen behind, do things like that, is that how DNA can be left behind in a scene?
Yes, we can also test bulk fluids, relatively large deposits or stains that could also have DNA that can be detected and characterized and compared.
Is it fair to say that what you refer to as bulk fluid, that contains more DNA molecules than touch DNA can?
In general, I would say so, that the amounts of DNA that might be expected with something like blood or saliva would be generally higher with respect to samples that we would characterize as a touch or a trace sample. But that's speaking generally, that's not to guarantee that, sample to sample, there's always variation.
Is DNA fragile, meaning that, like, just because someone touches something, does that automatically mean that they leave their DNA behind?
I can only speak to what is recovered when we do our testing, the results that we get. So just because if we knew for certain that someone did handle an item, it's not necessarily guaranteed that we would be able to test that item and recover results that would be consistent with that individual.
Do elements like heat, dirt, water potentially destroy or wipe away DNA?
There are a variety of factors that can influence whether or not DNA is damaged. So DNA can be what we call degraded, which is damaged over time. So things like heat, moisture, mold, bacteria, they can damage the DNA, which can impact and negatively influence our ability to get DNA profiles. And then DNA can be lost. It can be wiped or washed away.
So when you do your testing, when you have unknown samples and then known samples, Did you do both of those types of testing in this case?
Yes, an unknown sample would be a type of sample where if a DNA profile is recovered, the origin of that profile is unknown. So any type of crime scene evidence, something like a swab from a firearm, a swab from a vehicle, those types of things are what we would characterize as unknown or questioned or evidence items. And we contrast that with reference samples or known samples. And these are samples that are taken directly from an individual and are what represent their known reference profile. Those generally come in the form of an oral or a buccal swab. BUCCAL is a buccal swab, or sometimes we will receive blood samples where they'll draw a sample of someone's blood and deposit it on a card.
And so what is commonly done, and you do in this case, is you have these known or reference samples, and then if you develop DNA on one of these unknown samples, you compare the two to see if they are consistent.
Correct. That is the ultimate aim in trying to do a forensic DNA analysis, is we want to test the questioned evidence items and try to obtain whatever DNA results we can. There's a point at which we will determine if we do get a DNA profile, does it meet our lab's criteria to be suitable for comparison to references or not suitable for comparison to references. If we do have unknown profiles that are suitable for comparison, then we will take any known reference samples that we have and we will compare the profiles of those individuals to the unknown profiles and see if we can make determinations supporting either inclusion or exclusion of the individual as a contributor.
Is it common in your training experience to examine an unknown item and not find any DNA at all?
It is possible that we would test an unknown item, and some of the conclusions we may draw is one of the lab steps. We will estimate how much human DNA is present in the sample, and sometimes we do not detect any amount of human DNA present, and we would characterize that as no DNA detected. There are times where we might test a sample and there may or may not be an indication of human DNA present, but when we do the last step in our process and process the sample on the detection instrument, we get no detected data, and we would report that as no results. So those are some of the conclusions we might reach where we test a sample and we don't actually obtain DNA results.
And is it common in your training experience to actually find some amount of DNA, but that DNA is just not suitable for inclusion or exclusion?
Right, that is one type of conclusion we might reach as well. We might develop DNA results and observe a profile, but the profile may not meet our criteria to be suitable for comparison. So we'll make that decision. The profile is either determined to be suitable for comparison, it might be determined to be not suitable for comparison, and some profiles, occasionally with mixture samples, a mixture is a DNA profile that appears to come from more than one person, we may separate that into two separate components, which we would refer to as a major and a minor component. And within the context of a mixture at our laboratory, the major component is the part that is suitable for comparison. The minor part is the part that's not suitable for comparison.
Thank you for that explanation. Did you bring your file and review your reports in this case?
I did review the file and my reports. I have brought some selections of some copied materials in case I might need to refer to something.
I'm going to try to go through this fast. We're not going to ask you everything that you did, so just kind of follow my lead and we'll get through this. The most important question, I guess, for the state of Florida versus Mario Fernandez is, during the course of your comparison, did you find any of Mario Fernandez's DNA on any of the unknown samples that you tested?
We would never say with any certainty that we found someone's DNA on an item or that a person is definitely a contributor. What we would describe our results as is there support for inclusion of this person as a possible contributor? And to summarize the results from this case with respect to Mr. Fernandez Saldana, of the unknown profiles that had components or were entirely suitable for comparison, there was no support for inclusion of Mr. Fernandez Saldana as a possible contributor to the components that were suitable for comparison.
Same question with regard to Shanna Gardner. There was no inclusion of anything that you tested of her.
Same characterization with respect to the comparisons to Ms. Gardner. There was no support for inclusion of Ms. Gardner as a possible contributor to the suitable components of profiles that were suitable for comparison.
Or any of the police officers that you got known samples for?
Correct. We received a number of elimination samples from various law enforcement officials, and there was no support for inclusion of any of those individuals to any of the suitable components of profiles that were suitable for comparison.
Or Justin Bridegan, the brother of Jared Bridegan, no inclusion there?
There was no support for inclusion of Justin Bridegan to any of those profile components that were suitable for comparison.
Two more names, Jeremy Ordway and Jimmy Jones. Same question.
I know we received a reference sample from Mr. Ordway. I'm not sure about Mr. Jones. Could you refer to an exhibit number?
Yeah. It may take me a second. We'll go on to another part, and my co-counsel can find that.
I can't answer with respect to Mr. Ordway that there was no support for inclusion of Mr. Ordway as a contributor to any of the profile components that were suitable for comparison.
So, of all the items, and there were many items that you tested that did not either have enough DNA or had no DNA. Is that fair?
So some of the items may have been described as no DNA detected, which is where when we do that step where we estimate how much human DNA is in a sample, we did not have any detectable level of human DNA. There were some samples that fit that description. There were also some samples where we processed those samples on the detection instrument and there was no detectable signal, so those were no results.
So now we're going to get to the things where we do find matches. Beginning first, I'm going to talk about the shell casings number 3 and shell casings number 4. Did you find that there was an inclusion with regard to the victim, in this case, Jared Bridegan?
So those items in question, these are two 10-millimeter cartridge cases recovered from the scene, assigned lab exhibits 3 and 4. We will sample cartridge cases in pairs on occasion, which is what was done in this case. So lab exhibits 3 and 4 were sampled together. That resulted in lab exhibit 3.1. That sample was processed and there was a profile obtained from exhibit 3.1, consistent with being a male DNA profile, consistent with a single contributor. Upon comparison to the reference samples in this case, there was support for inclusion of Jared Bridegan as a possible contributor to that DNA profile.
Was there a statistical component that you would assign to show, to give the jury an idea of how forensically important that inclusion was?
So when we report any conclusion as a result of a comparison that is anything other than exclusion, we will report a statistic that is known as a likelihood ratio. A likelihood ratio is a value that can give weight or give support to either inclusion or exclusion of an individual. It is an assessment of how probable the evidence profile is under different possible explanations. One explanation is what we call the inclusionary hypothesis, and this is where we assume that the person we're comparing is a contributor to the profile. The other explanation is what we call the exclusionary hypothesis. This is where we propose that the person of interest is not a contributor, that other unrelated, unknown individuals could be the contributor. So when we do the comparison between Jared Bridegan and Exhibit 3.1, the likelihood ratio value is that it is at least 1 trillion times more likely to observe the evidence profile from Exhibit 3.1 if Jared Bridegan is the contributor than if an unknown, unrelated individual is the contributor.
I'm showing you what's been entered into evidence as State's Exhibit 94. You can see on your screen, State's Exhibit 88C and 88D. You see those? I know they're all bunched together, beginning first with 94. This has been introduced into evidence as the victim's blood spot card. Is that where you developed the full profile from Jared Bridegan? And if it's easier for me to just show it to you the whole.
Maybe if I look at it myself, yes.
I don't know why I'm saving steps. Sitting all day.
So it may be useful at this juncture to point out that at our laboratory, as the forensic biologist, I won't necessarily do all the work in the case myself. We do have lab specialists that assist us with laboratory tasks, and sometimes examiners will do various laboratory tasks for each other. I am the one who's responsible for all the analysis of the data and the reporting. And I bring that up because I see this exhibit, which is ATF and also Lab Exhibit 18, which is the reference sample from Jared Bridegan. This is not a sample that I actually received myself, but I do see the handwritten initials of the lab specialist that did process this item.
Okay, and then showing you 88C and 88D, the shell casings. Now, my understanding is those shell casings went through a process to extract DNA different from the normal swabbing. Is that true?
That is correct. At our laboratory, we used a specialized sampling technique known as the rinse and swab technique to recover DNA from fired cartridge cases. It is a technique that we developed in-house, and we published our research in a peer-reviewed research journal. As I look at these evidence packages, I see the lab specialist's handwritten annotation indicating these are lab exhibits 1 and 4 that correspond to 2 of the 10 millimeter cartridge cases.
Thank you, sir. So the jury has already seen the crime scene photos, and there's no reason to publish those again. But you'll have to kind of stay with me for this analogy. So the jury saw pictures of the deceased Jared Bridegan on the ground. He was bleeding heavily. They heard testimony that the victim was moved during the course of CPR. In other words, first responders got to the victim who was face down. They rolled him over. They performed vigorous CPR, and the victim was bleeding everywhere. They also saw that these shell casings were all collected in the immediate vicinity of the victim, meaning within inches to a few feet away from the victim. Is the finding of the victim's DNA on these shell casings consistent with the DNA being deposited on the shell casings after those shell casings had been fired and left onto the ground where Mr. Bridegan was found and CPR was performed upon him? Understand my question?
I heard your description. I don't know what the question is. I'm sorry.
Question is it consistent with your training and experience that the victim's DNA could have been transferred onto the shell casings after they were expelled from the firearm because the victim who was moving around, bleeding, performing CPR, and the collection of the shell cases all happened in the same area? Is that consistent with your training experience?
I have to be careful how I answer this. What you're describing is what we refer to as activity, which is how we would describe how DNA is actually deposited on items. I don't really have a technique or a method to try and evaluate specific activities as far as trying to determine exactly how a DNA deposition could have occurred. What I can say, which is what is seen in research studies, which I've observed in my own training and in creating training samples for others and in doing my own research, is that when we have, controlled studies where a volunteer will handle or come into direct contact with an item, and then we test that item, we do obtain results that are consistent with an individual coming into direct contact with an item. As far as can I extend that to say with any certainty whether endorsing your specific scenario that you've described, I cannot do that. I do not have a method to do that.
I appreciate that because you're a scientist. My question is not whether that's how the DNA got there, just that is within the scientifical probabilities of the world that yes, if a bleeding victim and shell casings are all rolling around the ground, there could be some transfer there, possibly.
I will say in general, if an individual comes into direct contact with an item, it is possible to test an item and get results consistent with that individual.
Thank you, I appreciate that. So now we'll get to, I guess, the meat of it, which is, did you find any DNA consistent with the known reference sample of Henry Tenon?
There were a number of questioned evidence items that were tested that yielded results that were suitable for comparison. And on comparison to Mr. Tenon's reference sample, there was support for inclusion of Mr. Tenon as a possible contributor to some of the evidence items.
Turning to the swab taken from the inner rim of the tire, was that consistent with Mr. Tenon? And could you explain to the jury your statistical analysis on number 11, the swab from the inside of the rim?
So lab exhibit 11 refers to the swab from the inner rim of the tire, and the cutting of that swab and the sample that we generated is lab exhibit 11.1. There was a DNA profile obtained from exhibit 11.1. That was a partial DNA profile consistent with at least 2 contributors. This was further resolved into a major and minor component. The major component was a partial DNA profile consistent with a single contributor. The minor component was not suitable for comparison. Upon comparison of Mr. Tenon's profile, there was support for inclusion of Mr. Tenon as a possible contributor to the major component of exhibit 11.1.
What was the statistical inclusion?
The likelihood ratio value for that comparison was that it was 1.38 million times more likely to observe the DNA profile from exhibit 11.1 if Mr. Tenon were a contributor with an unknown, unrelated individual than if it came from 2 unrelated, unknown individuals.
Okay, turn to the swab of the keys, the silver key that you took. Did you include Henry Tenon as a possible contributor to that silver key swab, number 30?
Lab exhibit 30 was the silver truck key, the sample that we took and generated the profile from. Lab exhibit 30.1. That was characterized as a DNA profile consistent with 2 contributors with at least 1 male present, and that was suitable for comparison. Upon comparison with Mr. Tenon's reference sample, there was support for inclusion of Mr. Tenon as a possible contributor to that profile. The likelihood ratio was that it was at least 1 trillion times more likely to observe the DNA profile from exhibit 30.1 if Mr. Tenon was a contributor with an unknown, unrelated individual than if it came from 2 unrelated, unknown individuals.
Turning to 33.4, the cutting from the steering wheel, were you able to include Henry Tenon as a contributor to that?
Lab exhibit 33.4 corresponds to a swab from the steering wheel of a pickup truck. That profile was a partial profile consistent with 1 individual. That was suitable for comparison. Upon comparison to Mr. Tenon's reference sample, there was support for inclusion of Mr. Tenon. The likelihood ratio was that the DNA profile is at least 1 trillion times more likely if it originated from Henry Tenon than if it originated from an unknown, unrelated individual.
We'll do the same process. May please.
Yes, throughout.
Thank you. States Exhibit 9, we'll start first with States Exhibit 95. Is this the reference sample from Mr. Henry Tenon that you or your fellow lab people worked on?
This sample I did initial myself, and I see our lab inscription and lab number. This is Exhibit 26, the reference sample from Henry Tenon.
Okay, and that's going to be States Exhibit 95. All right, States Exhibit 92 is going to be the swab from the inside rim of the tire.
All right, I see the handwritten inscription from the lab specialist who assisted with this case. This is Lab Exhibit 11, the swab taken from the inner rim of the tire.
States Exhibit 193 is going to be the swab from the silver key.
I see the handwritten annotation from the lab specialist, and this is Exhibit 30, the swab from the silver Ford truck key.
State's Exhibit 169 is going to be the swab from the steering wheel.
I see my handwritten information. This is Exhibit 33, 4 of 13. There were 13 swabs submitted as part of Exhibit 33, and this is number 4 of 13, which corresponds to the swab of the steering wheel.
Sir, I appreciate your testimony. I have no further questions at this time.
Thank you. Cross?
Just briefly, Your Honor, may I do it from the defense table?
It's fine.
Good afternoon, sir.
Good afternoon.
I didn't catch, where did you come in from?
I work at the Forensic Science Lab, Washington, which is located in Maryland, just outside D.C.
You flew in today, sir?
I came in yesterday afternoon.
Welcome, Jacksonville. I just want to make sure the jury's clear. You found nothing to include Mario Fernandez, is that correct?
Of the profiles that were suitable for comparison, there was no support for inclusion of Mr. Fernandez Saldana as a possible contributor to any of those profile components suitable for comparison.
Thank you, sir. I have no further questions.
All right. Any follow-up?
No, Your Honor.
Okay. May the witness be excused.
You may.
All right. Thank you.
Thank you, Your Honor.
All right. Members of the jury, that will be the last witness of the day. I ask that you leave your notepads on your chair. We'll see you tomorrow morning at 9 a.m. Please follow the communication rules. All right, thank you. Everyone may be seated. Please let the record reflect that the jury has left the courtroom. I'd like to inquire of Mr. Fernandez. Do you need a moment with him? It's about this incarceration.
I do need a moment.
Okay, all right. Just let me know when you're ready. Sure.
We can go back on the record, Your Honor. We've had an opportunity to confer with Mr. Fernandez.
Okay, thank you. So just so the record is clear, I was at the point in time where I would have to enter an order to sequester the jury for deliberation purposes. In the planning of this trial that's been months and months in the making, we discussed it. And just so the record is clear, the clerk's office is prepared to do it. And so they asked for the funds. And so I was getting to the point where I would have to basically enter in an order based on the parties' input about when we would be finished, because that was important, right? So, and I'm saying all this for Mr. Fernandez's benefit as well, okay? So I'm basically fast forwarding to near the end, and obviously the scheduling is largely up to the court, and once we give it over to the jury, we have no idea how long or how short it would be. It could be minutes, it could be days. And so we have to prepare for those things. And the clerk's office is prepared. So I inquired of the parties earlier, and I believe that the target date by all sides, I think you've been saying like maybe Thursday, finishing.
Yeah, Wednesday.
Thursday of
Wednesday
next
or
week.
Thursday, yes.
So that is what we were planning. And if the jury were to be sequestered, this is the process. And Mr. Fernandez, I'm explaining this to you, okay? On the day that the jurors would deliberate, what would happen is that the day before I would tell them, you have to pack your bags. Their bags would be searched, and searched not for, well, obviously contraband, but they would be searched for what we would consider contraband, something that could not be in a deliberation room, like crime mysteries, dictionaries, books, like that would somehow impact their decision in the case. They can have books, but they cannot be at all related to anything criminal or anything along those lines. It can be purely like entertainment, like a fantasy book. That could be a good example.
Bird watching.
Bird watching. And so those things would be allowed. The hotel would prepare individual rooms. The TV would be removed. The phone would be removed. And essentially they would go to the hotel. They would be guarded by the police. And they would have no outside contact until they came back to the courthouse to be back together. So to ensure these things, the reason why it's done that way is to ensure, number one, that somehow there's not some informal deliberation between the jurors when they're outside of court. They can only deliberate when all of them are together in a room. So that would short circuit that. And then, so that is the preparation that I'm going to ask you about, okay? So it's my understanding from the state of Florida that you're going to waive the sequestration, like if they, and this only happens, that is that hotel room, if they're unable to reach the verdict within a reasonable hour during the time frame of the day. So we wouldn't send them home. If they were sequestered, they'd go to this hotel under the conditions I've just described.
It's correct, of course, with the court's instructions that they aren't to deliberate, they aren't to do any research, so we know the court would give those instructions.
I reread the whole thing, and I'd also tell them the thing that I always kind of exclude, which is that they could be held in contempt of court. They could go to jail. They could, all kinds of things that I could do to enforce that if they violated this court's order, I'd be prepared to give them the full force of this court.
So we have no objection to that process.
So the other thing, and that is a consideration that I'm sure your lawyers have talked about, at the time of deliberation, okay, so once the arguments are done, once the law has been read, and they are ready to deliberate, I let those alternates go, okay? I let them go because then the alternates only stay there to the point in time in which deliberation. There is no ability, okay, to, let's say one of them, okay, during deliberations does something, okay, that is against the rules, whatever it may be, hypothetically. I couldn't substitute an alternate at that time. You understand? Okay. So I'm explaining all this because there's considerations on both sides. The state has decided that they would waive that. So I'm going to ask that you raise your right hand to be sworn in.
Sir, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Have you understood everything that I've said to you?
Yes, Your Honor.
Did you have any questions about the sequestration process? And it's only if they're unable to reach the verdict within the time period we give them a reasonable hour, then they would go to the hotel, they would return back, they'd have a whole nother day, and it could happen as many times as it needs to. That means they go back to the hotel to reach a verdict. So have you had enough time? Well, let me ask you this. Do you have any questions about that process? I'm happy to answer any of them.
I have no questions, Your Honor.
Okay. Have you had enough time with your lawyers? Have they explained kind of, what I've just explained to you?
Yes, Your Honor, they have.
All right. And do you feel, my understanding from Mr. Dreiser, let me ask you, what's the defense position on sequestration?
We agree with the state that under these very particular circumstances that they do not need to be sequestered in the event that it goes into the late hour of the first day of deliberation.
Okay. So to be clear, they're going to go home with the court reading the communication rules, maybe in more full force than I did before. I mean, I've been reminding them, but I'd add in that, how critical this is, that they cannot violate this court's order. So the defense is comfortable with waiving that.
I'll let Mr. Fernandez answer.
Yes, Your Honor, I'm comfortable with it.
Okay. And so this is critical for me, just like it's critical when I excuse those alternates. If they don't sign this contract, that is the clerk's office, and I don't put these things into motion, it's kind of too late to recapture all of that. You understand? So I need to kind of know today. Do you need any more time to think about it?
No, Your Honor.
Okay. All right. Well, I will find that the waiver of sequestration by the defenses, and Mr. Fernandez in particular, is freely and voluntarily entered. So that will be the procedure. We won't sequester the jury, but they will be admonished the way that I've just described for the record. All right. So is there anything that we need to take up before we break for the day?
Your Honor.
Not from the state.
All right, thank you. And for the state's purposes, I've been emailed that the Gardner issue is going to be passed to noon tomorrow, okay? And then my plan is for the Fernandez trial, instead of starting late, I'm going to start right on time, and then I'm going to take a longer lunch break. I think they'd rather enjoy that with like food or whatever than being stuck in the back with just like coffee or whatever, okay? All right. Court's adjourned.